and the Springbok in 2019. We have to come together against COVID-19. Enjoy your mask and the Springbok in 2019. We have to come together against COVID-19. And the Springbok in 2019. We have to come together against COVID-19. We have to come together. Enjoy your mask.
Good evening, everyone.
It's 6:30. If you're just tuning in, we have just passed live.
Are we ready to start? Yes, good evening. My name is repeal. I'm the chairperson for social development in the Gauteng legislature. I'd like to take this opportunity to welcome you all to this platform. We are very grateful that you honored the invite this evening. It is an important evening where we are going to be considering the amendments made to the social assistance bill. You are all welcome, and I would like to request that all of you should put your mics on mute so that we do not cause any interferences. I would want us to have a smooth running meeting without very little interruptions. This morning we had a physical meeting where we engaged some of our stakeholders, and I must say, we have received quite a number of inputs from the stakeholders that were present, and a lot of written submissions as well that we received. And we really want to appreciate and thank all the members that were there as well this morning.
Sorry, Madam Chair, we cannot hear you.
So I would like to first welcome members of the committee who are here with us, as well as all the stakeholders from the various regions and from across the province, and guests that are also based outside of our province. Also welcoming the support staff in the office of the chairperson, who are responsible for organizing this important session this evening. We really appreciate your hard work behind the scenes. And I just want to ask Mr. Sipho Nwala to, at this stage, table the apologies from members of the committee.
We have received the apology from Member Bosch, Member Mufama, Member Paternos. Thank you.
Okay. Thank you.
We can hear you, Madam Chair.
Hello?
Thank you. Now I can hear you.
I cannot hear at all.
We can't hear you, Madam Chair. No. We've lost you, Chair.
Public out there to participate in the decision making of government. And us as the portfolio committee and as the legislature, we are here to represent your views and to
We've lost you, Chair.
of the meeting. And I hope some of you, if you are not going to make presentations here, you'll be able to submit your comments to Mr. Sipho Ngala. And without any waste of time, I would like us to take a presentation from the National Department of Social Development on the Social Assistance Amendment Bill by, oh no, before we do that, I actually forgot to acknowledge our honorable member from the NCOP, Mr. Mbule.
Madam Chair, we can't hear you. Madam Chair, there's no audio.
So I was saying we are blessed to have Mr. Baha in our midst. Mr. Baha is a member of Parliament, precisely a member of the NCOP, the National Council of Provinces, who is the permanent delegate from Gauteng. And he will be responsible for taking our mandate as Gauteng province through to Parliament so that eventually the president can sign this bill into law. So I will invite Mr. Baha to just to greet you and also make a short input with regard to we can audit our state. Are you here, Mr. Baha? Okay, I don't see Mr. Baha, but as soon as he joins us, we will give him the platform to just give his input. So I will quickly call in Mr. Brandon to make a presentation with regard to the Social Assistance Amendment Bill. Brandon, if you can take us through the presentation, we will appreciate. Thank you.
Thank you, Honourable Chairperson. Good evening, and good evening to honourable members, as well as the member from the NCOP and members of the public that are joining us. I'm going to take us through, sorry, my name is Brenton van Friede. I'm from the National Department of Social Development. And I'm going to take us through the presentation on the Social Assistance Amendment Bill. Now, the Social Assistance Amendment, so the Social Assistance Act is an old act. It's been around since 2004. And it's basically the act that contains all the social grants. It's got all the rules for the social grants in terms of what the benefits are, who qualifies, and so forth. And our intention with this amendment is really threefold. The one is to empower the minister, with the concurrence of the Minister of Finance, to make additional amounts available to social grants. As some of you may know, that, for example, on the older persons grant, we pay people over the age of 60 who qualify for the older persons grant 1,860 rands, and if you're over the ages of 75, you get an extra 20 rands. Now, apparently, the minister wasn't empowered to make this payment when she did it a few years ago. And so we need to regularize this now by giving her that power, by empowering her to do so. But by doing this, we also allow her to implement what we call the extended child support grant, which is a policy that was approved in Cabinet in December 2016. And I'm going to speak a little bit later more about that policy. The other goal of this amendment bill is to remove the reconsideration provisions in the Act. And that is basically to streamline our appeals process. And then the third objective is to facilitate the establishment of the Inspectorate for Social Assistance. And then there are also a few smaller things like adding and cleaning up some of the definitions and aligning it to more modern definitions and other pieces of legislation. So in terms of that, the extended child support grant policy, which I've mentioned, that this bill will empower the minister to provide a top-up on top of the existing child support grant. Now, as many know, that South Africa is faced with a large number of orphans, and the vast majority of these orphans are raised in safe and secure environment, usually with a grandparent or with other family members. However, due to high levels of poverty in the country, the foster child grant has become the default grant over the child support grant. And this has created some challenges with the foster care system. Some orphans have managed, or the caregivers of orphans have managed to successfully navigate the foster care system, which is quite a long and complicated process because you need to get a social worker to come out, do an assessment. You then go to court, where you'll get a court order, and only after you get a court placement, and that process could take anywhere up to 2 years, if not longer in some instances, will you then be able to apply for a foster care grant. And so not many orphan or families looking after orphans actually are capable of navigating that system. And so a large number of orphans don't actually access the higher value of the foster care grant. But also this has also sort of clogged up our existing foster care system at the moment with all our social work and resources and our courts having to deal with this, to the extent that over the last 10 years, the Department of Social Development has been in and out of court, and with the court literally almost putting us under some kind of administration, in the sense of having to continuously extend those foster care orders, give a blanket extension for the foster care orders until the recent court judgment, which basically said we need to sort this problem out with legislation by November this year. And this is partly what this bill intends to do, to provide an easier way for at least for orphans that are living with family members to be able to access the child support grant, but not just the normal child support grant, the additional, we want to give an additional amount on top of that, so that it's that they don't necessarily need to go for the higher value foster care grant. But once they access the grant, they will still be referred to the provincial welfare departments, and a social worker will still be able to support the family. However, the need won't be as it is with the foster care system. The foster care system is more for children who have been abused or neglected and been removed from their families, and needs much higher levels of supervision. Whereas for orphans that are in safe family relationships, the level of supervision is not that high. So that will also then free up the social workers, so that they're not only just, I think at the moment most of our social work efforts are focused on the foster care system. And if these numbers are substantially reduced, the social work services are then freed up for other services as well. As I mentioned, Cabinet already approved this policy in December 2016, and the Treasury has also taken favorably to it by allocating finances for it in the 2019 MTFF. Unfortunately, because we haven't yet got this bill passed, we couldn't implement it in 2019, but we hope to implement it early in 2021 if this legislation is passed through Parliament. In terms of the appeals process, the second objective is to remove the reconsideration mechanism from the appeals process. So just a little bit of background. Currently, if you apply for a social grant and SASSA declines your application, you then have the right to appeal, and we have an independent appeals tribunal which will consider that appeal. But the current process is, before you can actually lodge your appeal with the independent appeals tribunal, you must first go back to SASSA and ask SASSA to reconsider. In other words, you need to ask SASSA just to check if they didn't make a mistake in your process. Now, when the legislation was developed a few years ago, that was a quality control mechanism we wanted to put in place within SASSA. However, SASSA systems have improved substantially over the years. They have their own quality control mechanisms in place, and we've now felt that it's suitable to remove this step, which has largely become unnecessary, from the appeals process, and therefore allow people to go directly to the appeals tribunal when they want to appeal. So you no longer have to go back to SASSA and ask them to reconsider your grant before you can lodge an appeal. That process in itself took 90 days or 3 months. You can now go directly to the appeals tribunal if your grant application is rejected, and that will then reduce the time for the hearing of an appeal from 180 days to 90 days. And that hopefully will give people better access to the social grant framework, or at least more speedy access to administrative justice. And then lastly, we want to change the organizational form of the Inspectorate. Now, the Inspectorate is a new entity that we want to establish. When the initial bill was passed in 2004, the President didn't promulgate Section 24 of the Act, primarily because at the time we didn't have sufficient resources to establish the Inspectorate. There's two entities in this Act, which is the Inspectorate and the Appeals Tribunal, and we chose rather to first establish the Appeals Tribunal, which we've done successfully and has been operating successfully for a while now. We now have the resources for the Inspectorate, and we've been incubating its structure within the department to prepare for implementation. But when we wanted to implement this, with the Department of Public Service and Administration asked us to reconsider the business form of the Inspectorate, partly because the original legislation makes or deems the Inspectorate to be a national department, and within the current government space, we don't necessarily want another national government department, and so we've been asked to consider making the Inspectorate a government component, as a component within the National Department of Social Development. A government component is very much like an entity, so similar to SASSA and other entities. The only difference is they don't have their own corporate services, such as human resources and finance and legal services and stuff like that. And so instead of setting up an expensive entity type function with the large administration, they basically will just piggyback or rely on the administration of the department, but they will still remain independent, and they won't necessarily report to the department, but directly to the Minister of Social Development, as if they were a normal entity. So basically, the amendment we want to make here is only that small change from a government department to a government component, and that will allow us then to implement Section 24 of the Act. As the chairperson mentioned, this bill was considered by the National Assembly and then transmitted to the NCOP for concurrence, and hopefully after these public hearings and getting inputs from the public, we hope that the provincial legislature of Gauteng will support this bill and provide a mandate for such to the NCOP. Thank you, Chairperson.
Thank you very much, Brandon, for the comprehensive presentation. I think this is these are very progressive amendments, especially the fact that people will now be able to appeal. As you would be aware that most of the people have got or have experienced challenges before in terms of the foster care grants and other grants from the SASSA. So I think this is a welcome amendment in terms of the Independent Tribunal and other amendments that have been made so far. And I would request that we mute our mics if we are not on the podium so that we can continue smoothly. We've had the presentation by Brandon, a very thought-provoking presentation, and I think most of you would welcome the amendments as presented by Brandon. And I would now, at this stage, invite clarity-seeking questions from yourselves so that Brandon can clarify a few issues if there are any issues of clarity. So I will take hands on the panel there. There's a gadget to raise your hand. You can just use the gadget, raise your hand. I will recognize you and give you the opportunity to ask your clarity-seeking question or to actually even make your input, as it were. So I see there's Les Sanabria, who has got a hand up. Oh, you took it off now. Okay, can I invite hands? Les Sanabria, I see your hand. Who else wants to ask a clarity-seeking question? Okay,
Thank you, Madam
Chair. Yes, you can go ahead.
Thank you, Madam Chair. I appreciate the presentation that Brenton has made, and the Gauteng Social Services Welfare Forum is basically in favor, but there are a few questions that we would like to bring in, and one of them relates to the fact that this bill could also serve as an opportunity to revisit that whole means test reference that Minister Pravin Gordhan used to refer to in his budget speeches as National Finance Minister, that was going to be done away with. And I was wondering if that could be dealt with. And then secondly, when it comes to the older persons, I was looking at the fact that it is at 75, but bearing in mind that we've had the COVID pandemic, could we not change that to make it 70 for older persons for that extra amount of money? And then the third question would relate to the tribunal. Brenton says it's already functioning, but as far as representation is concerned, would it be possible to have representatives from the South African Human Rights Commission that serves on the various Section 11 committees being on that the tribunal as it relates to children, older people, and disability grants, so that we could deal with this? I've had a personal experience where a lady was accepted for disability grant, but subsequently rejected, and she died of HIV/AIDS, and her daughter now gets the child support grant, but her mother could have been helped. So there are some issues that come in when you have a look at the tribunal and looking at these applications, and where doctors disagree with each other. Thank you, Madam Chair.
Thank you very much, Les. Is there anyone else who wants to ask a clarity-seeking question before I move to the next item? Can I have an indication if there's anyone else who wants to speak? You can raise your hand. If you can't raise your hand, you can just unmute your mic and speak. I don't see any other person who wants to speak. Okay, I will then move to item 7 of the agenda, where I will invite Ms. Zita Hansungule, who is from the Center for Child Law from the University of Pretoria, to make a presentation of her submission. Over to you, Ms. Zita. You can ascend the podium. Thank you.
Okay. Thank you, Chair. I just wanted to ask if you can see my presentation on the screen.
Yes, I can see it, ma'am.
Okay, thank you, Chair. So as you indicated, I am from the Center for Child Law, and I am making submissions on behalf of the Center for Child Law. And we just wanted to say thank you, Chair and honorable members, for the opportunity of being able to make these oral submissions. They are going to be very short and based on the written submissions that we sent to you, but we thought that this was important enough to come and make these short oral submissions. The Center for Child Law is an impact litigation organization based at the University of Pretoria. And what the Center for Child Law does is litigate on children's rights, as well as we do advocacy, research, and education-related activities. A lot of our work relates to advancing children's best interests, including issues around social assistance, access to basic education, birth registration, the rights of children with disabilities, and more. So we are coming here to express our support for the Social Assistance Amendment Bill, in particular Clause 4 of the Social Assistance Amendment Bill, which gives the minister the power to prescribe additional payments linked to the social assistance grants. And we are particularly interested in additional payments that would be made to the child support grant, as we believe that this would contribute to the development of a comprehensive legal solution to what is now being called the foster care crisis. As Brenton has explained, we are in a situation where the foster care system is taking on more children than it is able to take on, particularly due to an increase in orphaning rates. So children are having to be taken care of by relatives, often much older relatives who need some sort of social assistance to be able to provide this comprehensive care to children. And the best amount that they're able to receive is the foster child grant. Now, the problem with this is that we have gotten to points over the years where the system is taking double what it is able to take on. So we have a situation where we had a system that was originally meant to take on about 50,000 children, and we are going we've been in places where the system has had up to about 500,000 children. And this places immense pressure on the system, immense pressure on the children's courts and social workers who are having to follow up on foster care cases, who are required to follow up on foster care cases every 2 years. So our argument is that with the top up to the child support grant, we can divert relatives caring for orphaned children and children who don't need any other sort of additional assistance from social workers, divert the children away from the foster care system, have them receive the child support grant and give them a top up to the child support grant, which is going to ensure that the caregivers, relatives caring for children have sufficient financial support, and at the same time that we are taking off immense pressure from the foster care system, allowing social workers and the children's court to give attention to children who are actually in need of care and protection, children who are actually abused and neglected. That being said, this does not mean that our relatives who are caring for orphaned children are not going to receive support. So the way the Children's Act is structured now is that even if a child is not in need of care and protection, but they are being cared for by somebody, or their family needs some sort of additional support, such as grief counseling, maybe elderly relatives need care, need support to be able to care for teenagers who have behavioral difficulties, then such support can be provided to them. So we're not arguing for a complete separation from provision of additional support. We're just saying let's use two different systems so that we do not have a situation where the foster care system is overburdened. Now, what the overburdening of the foster care system has resulted in is ongoing litigation from 2011, and I'm going to explain that briefly and also explain our concerns around this ongoing litigation. So in 2011, a number of non-governmental organizations working in the child care and protection system noticed that the high strain on the foster care system due to an exponential increase in the number of children entering the foster care system. Like I said before, it means social workers are overburdened and children's courts are overburdened and not able to do the work that they need to do. How the foster care system works is that when a child is placed in foster care, the social workers and the children's courts need to review that placement every 2 years. That means a social worker needs to go and do an investigation, look at the circumstances of the child, write up a report, and take it to the children's court. Now, this makes it difficult when one social worker has got hundreds of files and she cannot visit all of these homes and provide the necessary care that is needed. Which we have found, one of the things we have found this does is that it takes away critical care for children who are actually abused and neglected and need the critical care from social workers and children's courts. So now in 2011, it was found that there were over 120,000 foster care orders had lapsed because social workers and children's courts were not able to get to them. What this means is that because their system was so overloaded, the workload was so high, social workers and children's courts were not able to renew foster care orders every 2 years. So their foster care orders for over 120,000 children lapsed. What this means is that when your foster care order lapses, SASSA cannot pay your grant because you need a court order for SASSA to pay your grant. So children now were losing out on foster child grants. So a number of non-governmental organizations working with children in foster care approached the Center for Child Law and explained the situation to us and asked us to approach a high court, the high court, for some sort of relief because children were losing out on the critical foster child grant. So the Center for Child Law wrote up court papers. These court papers were served on the Department of Social Development, and the Center for Child Law and the department eventually reached an agreement. And this agreement was made an order by the High Court. And what this agreement does is that it places a temporary solution on the foster care crisis. So it's a band-aid, it's meant to be a band-aid solution where the High Court essentially says that all of these orders that have lapsed are deemed not to have lapsed. So without any social worker investigation, without any children's court involvement, all of the foster care orders that lapsed are deemed not to have lapsed, and therefore foster care parents can now go to SASSA to get their foster child grant. So now, and the other thing the High Court said is that during this time, during a 2-year period, the Department of Social Development must do an investigation into the foster care crisis and come up with a comprehensive legal solution to the crisis, because the renewal of the foster care orders by the High Court was just a band-aid solution, a temporary solution. Now, since then, the High Court order has had to be extended 3 times in 2014, 2017, and 2019 because a comprehensive legal solution has not been created. And this extension was done to prevent further lapsing of court orders, because every time we got to the end of the 2-year period that was given by the High Court to create a comprehensive legal solution, and nothing was put in place, foster care orders were lapsing. So the Center for Child Law and the department had to come to an agreement to extend the High Court order. Now, Yes, so the latest extension was in 2019, and it comes to an end November 2020. And in the same court order, the High Court says that the department, the minister must come up with a comprehensive legal solution. Now, we believe that the social assistance bill is part of the comprehensive legal solution that the department is meant to come up with, and we support the social assistance bill. We believe that it will help take pressure off the foster care system, at the same time provide much needed financial assistance to relatives who are caring for orphaned children. Now, our argument is that the social assistance bill is part one of a comprehensive legal solution. The Children's Act is also going to have to be amended, and we believe that the Children's Act is now we believe that the Children's Act is now with Parliament. So just to again say, Chair, that we support the bill and urge this committee to put it into effect. Thank you, Chair.
Okay, thank you very much, Zita, for the comprehensive submissions. I think they will definitely strengthen our discussions, and I think these are valuable comments that you have made. I hope Brendan was listening carefully there. Maybe just to say that we also received written submissions from the University of Cape Town, from the Children's Institute of the UCT. But unfortunately, they are not here to present their submissions orally. But we do have in our possession their written submissions, which is also highly appreciated. We thank them very much for making these submissions way ahead of time. And at this stage, I would just like to check with the members of the committee if there are any who would want to ask further clarity-seeking questions from Brendan, from the presentation made by Brendan, because I want to, when he responds, to comprehensively respond to all the issues. If I can get an indication if there's any member of the committee who wants to raise something with relates to the presentation that Brendan made, I would take that, or any other person who wants to make who wants to ask a clarity-seeking question before Brendan responds. Or if there's anyone who wants to engage the submission made by the University of Pretoria, can I get a hand, an indication? Okay, let me check. Okay, if there's no one, then I would request Brendan to come in and respond to Les.
Thank you, Chairperson.
Okay, so Brendan, can I just interrupt you? I see there's Virginia Kliani here. Can I just take her hand before you respond? I'm sorry about that. Okay, Virginia, you can come in. Virginia Kliani, come in. Okay, okay. Brendan, you can come in. Hello, Brendan. Oh,
sorry.
I see. Yes, Virginia. Okay, yes, Virginia. Let's take Virginia first. Okay, you're welcome, my dear. You can access the podium. You can speak to us. Just unmute your mic, Virginia. We can't hear you. Your mic is mute. Just press that button for the mic and unmute it.
Unmute.
Okay, go ahead. You are fine now.
Okay. No, I support the bill. I wish it can be signed. But my question was, the foreigners who get a grant, are they within the law, or are there any reasons why they are getting grant for their children? Thank you.
Okay, thank you, Virginia. You can now mute the mic again. Just mute it, and then let's allow Brandon to respond. Thank you very much, ma'am. Okay, Brandon, you can come in.
Thank you, Honorable Chairperson. There weren't many questions. I think just maybe overall from Zita's presentation, I was supposed to thank the Center for Child Law for their support, but also just to mention to Zita that, and I suppose they'll be very interested in the regulations that will have to be published once the bill is approved. And just to give them a sense, you know, we're looking at publishing these regulations roughly in November. And we will then again, once again, appreciate comments from them when we do the regulations. The question from the Social Services Welfare Forum around the old age grant means test. This still remains a very important policy of the department. However, it is quite an expensive policy to implement. I think it will cost more than 10 billion rands to implement this particular proposal. However, the means test is not necessarily in the Act, it's in the regulations. And so when the financing and the funding is available for the removal of the means test as made by both the Minister of Finance and Social Development a few years ago, we will then be able to implement it without necessarily a change to the actual Act. We take the input around lowering the age from 75 to 70 for the extra top up. Obviously, we can't make a commitment to that, but we can consider it, and we will have to look at the costing of that and see to what extent we can afford that. On the question around foreigners raised by Virginia, the law does provide for permanent residents as well as refugees to access social grants, and it also provides for children of any nationality. In other words, it doesn't put a restriction on children. However, the parents must be South African. So the children have to be with South African parents, and this does create a little bit of challenge, for example, when, especially on the cross-border, where you're close to the borders, where one parent might be a foreigner and the other parent is a South African. Our law treats those children as South African if they're living with their South African parent. But that's not always the cases, and we do have to work quite closely as well with Home Affairs because sometimes we do also find that there is some grants that go to foreigners who aren't necessarily, the parents aren't necessarily, the caregivers aren't necessarily South African. I'm going to ask my colleague, John Mukwele from the Appeals Tribunal, to respond to the question around how we appoint the independent members of the Appeals Tribunal. John?
Okay, thank you, Mr. Van Friede. How the process has been currently that the minister advertises in the paper to appoint lawyers and doctors who will be participants in the tribunal to be appointed as members of the tribunal. However, the changes that have been now are being inserted is that after the minister have made the advert and before she appoints, she must consult with Parliament to assist in making appropriate appointments of members who are fit and proper to be in the tribunal. The tribunal consists of doctors and lawyers who are independent practitioners, not employed in any public sector institutions, who are not employees of government, who are then coming in as independents, who are going there to make own independent decisions, which are not influenced by the minister, nor influenced by SASSA, nor influenced by officials in the department who are serving as administrators to the tribunal. So our tribunal is indeed independent, and their decisions are also legislatively protected in that they are final, unless a person is still aggrieved by the decision, then can take them to court for review of that decision based on review processes that maybe the tribunal did not follow processes, or his decision is beyond the limits or the provisions as provided for. So that is what it's provided for in terms of the current tribunal that is currently existing, which will then run until the new provision that will come in, that will then provide for the minister to consult Parliament when making appointment. Thank you. I trust that I've assisted.
Okay, thank you very much for the clarity. I think it helps a lot for people to know about how the tribunal will work, and that they do have a mechanism for appeals. I think that's very, very welcome and appreciated. Let me, okay, Les. Okay, you can come in, Les.
Thank you. John, I appreciate you saying that they're lawyers and doctors, but as I've said, the doctors are not respecting decisions made by government doctors and proper tests done. And I know of a specific person that has died because her application was rejected after 2 reviews, and she passed away just before COVID started. And now her daughter is at the mercy of neighbors, and there's no care. So I'm a bit worried about the fact that we're just having doctors and lawyers that might be independent. I appreciate that. But I think, for instance, as a member of the Human Rights Commission, I feel that we need to look at that child and also the mother who passed away. Maybe we could have helped her.
I think if the person maybe would have through your chair appealed, because remember, once a person has been rejected as SASSA, it is now the responsibility of the person to lodge an appeal with the independent tribunal, which has an opportunity then to review the doctor's decision or recommendation to SASSA whether or not to grant, in relation of not to grant the appeal. So what happens is that if that person appeals, the tribunal has an opportunity to also refer the person for second medical opinion in instance where the medical reports on hand do not provide sufficient information for the tribunal to make an informed decision. So these are the power that the tribunal has, in that they can refer a person for a second medical opinion for them to then make an informed decision that says this person is indeed disabled or this person is not disabled, because now they will be having further medical report that provides for medical circumstances or the medical diagnosis that have been determined by the attending doctor. Thank you.
Thank you very much, John. And
Thank
let me also appreciate the written submissions from yourself, Chair Les, from the Gauteng Welfare Social Services Development Forum. We really appreciate the written comments that you have sent through to us. And let me at this stage also welcome the Honorable Baha. I see he has now joined the meeting, and also thank members of the Portfolio Committee who are here for their sterling contribution throughout the preparations for this session. They are Member Dolili Dwaba, Member Alfina Ndlovana, and Member Togo Makagula. Those are the ones that I can recognize from the participants list. Thank you very much, members. And I would like to call upon the Honorable Baha to maybe just make his input and give us closing remarks and a way forward. Honorable Baha, you can now come in and talk to our participants. Thank you very much, Honorable Member.
Thank you, Chairperson. I hope I'm audible enough. Chair, good evening, and good evening to everybody who's part of this session. I think that it's quite encouraging that one has to represent the plight of a province that is able to stand up and raise issues as they see them, because in that fashion it then gives you more strength and guts to stand for what the province is up to. I know that when we met sometime in August, Gauteng had responsibilities, and that the members of the legislature were not part of that gathering. But it's quite encouraging that we did have a session, and after the session, we are having these two meetings that we had today. And the encouraging thing as well is that this has been passed by the National Assembly, and it's now at the hands of the NCOP for us to take it to its logical conclusion. And Chairperson, I want to assure everybody who made a contribution, including those that we met sometime during the day, that nothing will be left without consideration. We will look at all the contributions that were made before we make our own contribution in the NCOP. So, Chairperson, mine is just to say that firstly, I apologize for being late. I had to rush for another meeting, and that took me some time. And so, at least when I got in, I found that everything is in the go, which is quite encouraging, Chair. And I think from here, Chairperson, I get a sense that most representatives are happy with what we will be putting forward as Gauteng, but also they also have additional issues that they think might assist us in moving forward. So I'm happy, and I think that we've done well as a province, and I appreciate everything that has been put forward, and will therefore deal with it and handle it accordingly. And once everything has been sorted, which is going to happen by the end of this month, everything will be, there'll be a sense of where we're going. And therefore, Chairperson, I want to thank you and thank everybody for making time to make sure that they make a contribution that will assist us in moving forward. I know that it's not enough. There's still a lot that people want to see being done by our government, and we will then take it step by step and get to where we would want to be eventually. Thank you, Chairperson. Thank you so much.
Thank you very much, Honorable Baha, and thank you so much for gracing this occasion and talking to the people of Gauteng as our representative in the NCOP from Gauteng. I'm sure we will be, like all our counterparts from other provinces, we will be able to make our submissions and have the voices of the people of Gauteng heard in our parliament. And when the president signs this into law, we will have the pride to say that at least we have made inputs as Gauteng. And I want to also thank everyone who participated in this meeting. And I want to assure them that once this bill has been signed into law, they will get to know about it. And I'm sure in the president's weekly newsletters, he will be able to articulate that. He will indicate when the bill has been signed into law. And I'm sure SASSA, as the custodian of this program, they will be able to come up with programs to inform the public as to what is in the bill, the amended bill, so that all the people of Gauteng are quite conversant with the bill. So I really want to thank each and everyone as well for making time to spend with us this evening and from this morning, and also welcome all the submissions. They are enriching us, and we are, we are what we are, who we are, because of the people of Gauteng. and we stand very proud to represent them in our various legislatures, and we look forward to working with them going forward. And I'm sure the committee, the Portfolio Committee on Social Development, will again meet tomorrow morning at 10 to finalize all the inputs and make our recommendations to yourself as the NCOP so that you can take them forward to Parliament. So I want to assure them that these inputs are not submitted in vain. They will be considered, and we will do the right thing. So I thank you very much, and I hope that you all continue to take care of yourself, continue to follow social distancing, and follow all the health protocols. COVID is still out there, so let's all respect it and take care of ourselves, because our lives matters. I wish you a very good evening at this stage, and thank you so much. The meeting is adjourned.
Thank you, Chair.
Thank you.
Chair.
Thank you, Chair.
Bye-bye.
Good
Thank you,
night.
Chairperson.
Thank you, Chair.
Night.
Thank you, Chair.
Good night.
Be good.
Thank you. Night.
Bye-bye. Bye-bye.
Bye.
Okay, the meeting. Okay, to drop.
Okay.
Bye.
Your leave.
What
a message.
What is something?
Okay. Mama na boy. Ato may lang mo.
SASA.
Weekly newsletters. He will continue to follow social distancing and follow all the health protocols. COVID is still out there. The meeting is adjourned.